And I know many of you are interested in this as it affects our overall land use policy and what some of our decisions are. So we're excited to have Brent and Jim here. So let me throw the ball. Doug, can you help pick that up? And we'll turn the presentation over to Brent and Jim.
Great. Well, thanks, Jason. We sure appreciate that. And I'm Jim Wright, an attorney with the Office of the Property Rights Ombudsman, and I'm pleased to be here with Brent Bateman,
Hello, everybody.
The lead attorney in our office. And as Jason mentioned, we're going to be talking about some land use legislative updates here from this past legislative session. And we sure appreciate the invitation of the trust and for Jason and Doug helping us out here technically. And as Jason mentioned, if you do have questions during this presentation, feel free to throw them out to us. We're happy to take them either during our presentation or at the end. It'll be a pretty informal presentation. Brent and I will be discussing some things back and forth, and don't mind at all taking the questions.
Yeah, we've ordered the slides in order that from most important to less important, or at least from the ones we get asked the questions about most to the ones we get asked the questions about least. So don't worry about whether or not we get through the whole set of slides. We're going to try to get to the important stuff first. If you have questions about the important stuff, it means more to us to have you have your questions answered than that we get through all the slides.
Right, especially since I have the last slide. So no worries on that one if we don't get there. But maybe to start us off here, we can just have a very brief, sharing of thoughts on this last legislative session. I know that to give it some context, in the land use area, from the local government side, last session was often characterized as the death by 1,000 cuts session, where there were lots of land use bills and there were lots of bills that ended up taking away little bits of land use authority from local jurisdictions. And I think, Brent, it's fair to say that this session was perceived differently.
Yeah, it was a little bit better, but in partially because some of the things that happened this session were an attempt to prevent the death by 1,000 cuts effect from happening. So it was a quiet session, not that there wasn't a lot of bills and not that there wasn't a lot of controversy, but a lot of it was sort of worked on either behind the scenes or in advance. So there didn't have to be a whole lot of shouting and fist shaking and stuff during the actual session.
And for us, I think you hit it there. This was certainly a quieter session for our office in terms of any sort of involvement on the Hill or things of that nature. And I think that leads us in a good segue into our first bill here. Okay, so HB 232 Land Use Amendments from Representative Mike Schultz. This was a big bill, as Brent mentioned. These are ordered from most important to least important, and this was the big land use bill of the session, and it was worked on quite a bit. And Brent, maybe you can, given your involvement, give us some idea and some context for this bill.
Can they see the new slide?
Yeah, they should be seeing this.
They should be seeing this? Okay.
Yeah. I don't know why it changed.
Jason, can you see our slide we switched to?
They changed the slide, and it looks like the other slide is still showing on your screen.
Yeah. This is why I wore a tie to this, by the way. I never wear ties, but this is why I wore a tie, so I like to dance.
It's showing. Look good. Okay.
Oh, very good. Thank you, guys. HB 232. This is the big one. This is the big land use bill. This bill came out of the Land Use Task Force. If you're not familiar with what the Land Use Task Force is, it's a group that meets over the interim. We meet fairly frequently. I meet with this task force, but I'm the neutral person. It's a task force of people who represent the entire spectrum of land use folks, people from counties, people from cities, local governments, special districts, along with the developers, home builders, all those kinds of folks. We meet together with the idea of trying to hash some of these complicated issues out in advance so that, like I said, when we go to this session, it ends up not being a big fist fight. We do sometimes get pretty excited in the Land Use Task Force, but that's kind of how good laws are made, is through debate and everyone being able to express themselves. This is the major bill that came out of that. And this bill is definitely a response to the death by 1,000 cuts problem we were having. You know, certain people complained about the whole idea of the state regulating what local governments should be doing and should not be doing with land use law, and the state saying, hey, you can't do this, you can't do this, you can't do this, you can't do this all the time. You know, the idea that that was going on, you know, was objected to, and the response from the legislature was, well, you're not getting it right. We're having to do that because you're not getting it right. And there was a real effort to look into why they would say that and what was not right about it. And the conclusion was that the law and the structure were there the way they needed to be, but no one was following it. Not necessarily out of you know, bad motives. They weren't following it because it wasn't clear enough or it wasn't well enough understood. And so this bill is the result of trying to straighten that out. This bill is an attempt to help people know what they need to do locally so that they can follow the law locally, right? Which will prevent future death by 1,000 cuts problems, which will prevent the state from thinking that they need to micromanage what local governments do. So the result is this bill. Now, the problem with this bill, Jim, is that it really doesn't represent a change in the law. And people who are talking about this bill are saying that. That's kind of the message. It's not a change in the law. But that's really dangerous to say. Because as soon as someone says, well, this bill doesn't change the law, it just clarifies or whatever, people shut down.
They just go back to what they were doing previously.
Exactly. They think, well, if it's not a change in the law, I don't need to do anything. I don't need to make any changes. But the whole point of this bill was to take the existing law and bring it together in a easy to refer to and easy to understand things so that local governments will understand it and be able to come in and comply better.
Okay, and that makes sense. And so I see, you know, we have a couple of the highlights here, maybe some of the areas that were points of confusion that have been highlighted in this bill. And so I see, you know, obviously starting off with the legislative versus administrative roles and differences.
Yeah.
What sort of changes or clarifications are made in this bill?
There's been efforts by a lot of trainers and people who go around, like from the league, and I've certainly done it, and go around to try to make sure people understand the difference between legislative and administrative decisions. But the persistent problem is that we've been saying one thing, and what the statute has reflected. It's been hard to reconcile what people have been saying to what is said in the statute. It's there, but it was hard to get it all together. And so that's a perfect example of what we're talking about here, about getting it together in a well understandable way. And so what they've done is they've made a distinction, a brand new distinction between a land use regulation and a land use application. A land use regulation is a land use law, and making decisions about land use laws, land use regulations, are legislative decisions. Whereas making decisions about land use applications doesn't create the law, it applies the law. Those are administrative decisions. And so the idea is, if we understand that one is a land use regulation, a decision about a land use regulation, one is a decision about a land use application, that will make the distinction between a legislative and administrative decision clear.
And was some of the point here to clarify that it doesn't matter who the body is?
Yeah.
Meaning, so whether it's the legislative body making an administrative decision, wasn't there some confusion about that at times?
Absolutely. And there still is in a lot of places. Matter of fact, that is one of the major sources of a death by 1,000 cuts. The legislative versus administrative, it's important to understand the distinction because they're treated differently, they're appealed differently. How you handle the public is different between those two things. But you often get legislative bodies, which would be the county commission, the city council, making administrative decisions about land use applications.
So it's land use authority.
Exactly. And one of the biggest problems is if that gets foggy between what kind of decision it is, the land use authority will make a land use application decision, an administrative decision, using their legislative process or their legislative power, or they'll even try to pass a land use application as a piece of legislation. It's a disaster. And so one of the things that this law does is this law says that it doesn't matter if the legislative body is making an administrative decision, it's still an administrative decision and it's handled administratively. So it clarifies that in that way. That's a good example. Another good one, another good example of what I'm talking about how this bill doesn't change the law, but it's critically important that it be used to change how it's done locally, is this section that talks about the plain language. It's longstanding law that locally you interpret your own ordinances using the plain language, right? It's longstanding law. And I think everyone knows that to a certain extent, but it's nice to have that in here to say a land use authority shall apply the plain language of a land use decision. But the next part is the critical part that very, very few local governments, it's part of the law, but very few local governments were following. The next part says, if a land use decision does not plainly restrict a land use application, the land use authority shall interpret and apply the land use regulation to favor the land use application. So what that means is that you use the plain language to restrict what people can do on their land. If you plainly restrict what they can do, you're good. But if it's not plain, if there's room for interpretation, the tie goes to the developer. The tie doesn't go to the government. And that's a frequently misunderstood thing. People think, well, I'm just going to interpret, it's open to interpretation, so we're just going to interpret it in the government's favor. And that's not the law, and it hasn't been for a long, long time. The law is, if it's vague, then you interpret in favor of allowing the use on the land. And so that is now in the codes, just to make that clear so people won't be confused.
And my understanding is that for some of this, they brought case law in to the actual statute, just so, again, there wouldn't be that sort of misunderstanding, or it'd be plainly accessible to everyone in terms of what the proper way to interpret their ordinances and restrictions are.
That's a great point, Jim. You know, the whole thing was really helpful to us attorneys because it was a nasty jigsaw puzzle we put together. But helpful to us attorneys, you know, only gets you so far because it's local citizens who are making these decisions. And so we wanted to make this helpful to the local citizens. So yeah, we brought the jigsaw puzzle together and tried to assemble it here so it would be easy.
So I think this is an important particular example when you're talking about this was the law before, but it's important not just to think that everything can go on the way it was, because this type of interpretation was not necessarily happening everywhere.
Exactly right. Exactly right. And that's what was causing the problems. The problems were causing the stories up at the Capitol, and that was causing them to try to regulate what local governments do.
Right. Okay. Great. And I think we talked about the administrative decisions by the councils, you know, the legislative bodies. And so in terms of plainly stated standards of review, you know, there's some you know, how appeals are handled. I think this bill, you know, again, doesn't necessarily change things, but maybe clarifies.
It clarifies it with the hope that it will be applied better. The standards of review have always been, for a legislative decision, it's always been reasonably debatable. For an administrative decision, it's always been substantial evidence on the record. The whole step-by-step process now is though, in the code to make it easier to use as you're actually making decisions and as appeals are going on. You have to find whether or not something is arbitrary, capricious, and illegal. If it's illegal, it's illegal if it violates an existing law. That's easy. Arbitrary and capricious is where the standard comes in. A legislative decision is arbitrary capricious if it's not reasonably debatable.
That's a very low standard.
It's a very low standard. All you got to do is be able to look someone in the eye and say, I think this is what's best. Administrative decision has a totally different standard. Administrative decision is arbitrary and capricious if it's not supported by substantial evidence on the record. Still not a very high standard, but it's much higher than the legislative standard.
And can you just clarify maybe what substantial evidence is briefly?
Substantial evidence is, it's defined by the court as that amount of evidence necessary to convince a reasonable person. It's not a preponderance of the evidence. It doesn't mean the most or the best. It's just enough evidence to convince somebody.
So it's likewise a pretty low standard, but not quite as low as the...
Exactly, and it's got to be evidence, not opinions, not clamor. It's got to be factual, probative, and relevant evidence.
On the record, so it's going to be there in the record from the land use authority there.
Right, and so that's one of the reasons why it's important to know if you're making legislative or administrative decisions, so you know what you need to back it up.
Okay, right.
But it's all now spelled out in the statute. Again, not a legal change, but you shouldn't just zone out because you're having like I said, there's no legal change. It's there to encourage and enable change.
And to prevent future legislative, from the local government side, encroachments on the ability to regulate land use law.
You got that right.
So,
Yep.
okay. Right. And so we have here the final bullet point here on stricter requirements. There's a little clarification there.
Stricter requirements. There's a section of LUDMA that a lot of you are familiar with about stricter requirements. It is the biggest nightmare in my life, because I will get calls from both sides, from the city side and from the developer side, both claiming that the stricter requirements section of LUDMA should favor them. And it's just become sort of a controversial nightmare and another cause for problems up at the Capitol Hill. So the effort has made to sort of clarify that, okay? Stricter requirements doesn't mean that you can go beyond the state law. If the state law on something like, say, for example, non-conforming uses, the state law on how to manage those, on how to eliminate those, and all that is the state law. And you cannot go beyond that. You cannot say, I'm doing stricter requirements than you, so I don't have to recognize this non-conforming use. No, you have to follow the state law. To that extent, as long as you're following the state law, stricter requirements are okay. But I would be super careful before I ever tried to do something relying on that stricter requirements rule, because it's problematic, and it's the kind of thing that causes problems.
Litigation even at some point. So.
Absolutely.
So. Right. So yeah, there's a great overview of this HB 232, the main land use law from this past session. Again, it's important, I think, and I appreciate that context in terms of understanding where it came from, so that I think there's maybe more motivation then to pay attention to it and get things right, so that things do not end up back in this death by 1,000 cuts, as many felt it was. So
the code reference to this, by the way, this bill refers to many codes. I'm looking at the list of the code references that were amended with this bill, and it's like 25 of them, but they're all in LUDMA, which is section 10.9a, starting with 101, going all the way through, and also 1727a for counties. This particular bill amended many sections of LUDMA. So if you want to know specifically about where something is or where it's found, feel free to call us, though. We'll zone you right into the spot.
Happy to help. So we'll go ahead and move on here to another hot bill this last session, HB 253, short-term rental amendments. This is one that came back. There's a lot of discussion about this last session. It was worked on in the interim, and was another major point of discussion between various sides on this. And so can you give some background on this one, Brent, maybe, given your involvement in it?
This is the kind of bill, an example of a bill that came in as a sword and was beaten so much that now it looks like a piece of tinfoil. How's that for an analogy?
Okay? That was pretty good. I thought that was pretty good.
There you go.
I hadn't heard that one before.
This, short-term rentals are a big thing now, and they haven't been for very long. And so the whole question is, how are we going to deal with them?
Right.
Last year's session, not the one that just ended, but the one before that, there was a bill that was proposed that got far down the road before it finally got stopped at the end, to say that local governments could not prevent people from short-term rentals in any circumstance.
Right. The Airbnbs, the VRBO, all that good stuff.
There's nothing you can do in any zone, any area. That's how the bill started out.
Mm-hmm.
And like I said, it got a long way, went a long way.
Yeah.
A lot of people who are concerned with property rights feel like that you should be able to do what you want with your land, including rent it out, right, for the weekend. That got stopped last year with the idea of it was going to get picked up this year, and it was picked up this year. And to a certain extent, like I said, it got reduced down to where there's very little of it left, but it's coming back. It's coming back, I guarantee it. All this bill does right now, rather than saying that a local government cannot prohibit short-term rentals, is it says a local government cannot prohibit or prosecute someone for advertising a short-term rental. So you may have an area in your city or county where you don't want short-term rentals, and you may have a law that says no short-term rentals in that area. That law's fine.
This bill, just to make sure we're 100% clear, does not change that.
That's right. You keep that law in place, and that's still a law, and you can enforce that law. But even if someone lives in there and they post on VRBO, I have short-term rental for rent, you cannot go, hey, you're posting on VRBO, so I'm prosecuting you, or I'm giving you a fine, or I'm
telling you to take it down.
You can't do that. You can't even tell them to take it down. They can advertise,
yeah.
Which basically means that's the way that most people enforce those things. Which basically means that if you have a regulation prohibiting short-term rentals, you really have to catch it in the act. You have to catch it in the act in order to enforce your regulations. It takes away a lot. It takes away a major source of enforcement.
The bottom line is also on this one, stay tuned.
Yeah,
it's
for sure.
This one is not on the tinfoil may get new life.
Yeah, I think it will, especially as time goes on and short-term rentals become a bigger thing, and they sort of see how this works, and they see whether or not it becomes even a bigger thing, and whether or not there's more regulations and more restrictions. The more restrictions to put up, the more likely it's going to come back.
Right. Okay, on to the next bill.
Local government licensing amendments by Senator Anderegg, SB 81. I thought this one was interesting. Jim, what did you find in your research on that?
So basically what this bill does is it makes a couple of tweaks. The first thing I want to highlight is it makes a clarification in this bill that when a government charges a fee relating to the licensing of a business, the old language used to have the word revenue in it. This bill strikes that out and says and clarifies that the fee that you charge is only for recovering the costs of regulation. And so, again, that does not change the law. That's always been that's the law in Utah with fees. Fees are not taxes; they're not to raise revenue.
Impact fees,
right.
Connection fees, all those kinds of fees. It's the law that covers them all, right?
Right, and it's basically that you can only charge these fees to recover costs. It cannot be used to raise revenue. But we do get calls on this, and there's sometimes some misunderstanding about that comes to our office. So it was a great clarification in this particular bill that reminded that the fees are for the recovery of the cost of the regulation itself. It's not for revenue. So that's the first thing I would say. I would note that, Brent.
Yeah.
So
I did see a similar bill last year by Senator Anderegg. He was Representative Anderegg at the time, and it's really started out as trying to prevent business licensing altogether.
Right.
I know there's a lot of people who feel like the business licensing is sort of to a certain level amount of government overreach. So I guess this is a compromise too. Right,
and so this one, I wouldn't say that this one necessarily got beat down to the point of being tinfoil, but it certainly was mitigated in terms of the effects that it had on businesses overall. So this now regulates a couple of specific instances. The first is if there is a business that is run by anyone that is under 18 years of age and it is only done intermittently, there is no provision for licensing that business at all. And so if you have kids or there's kids in your jurisdiction that want to open up a lemonade stand on occasion, or maybe someone's doing periodic lawn work, there's a child, a teenager that has a little lawn business and they mow a couple lawns every once in a while. I think that's the sort of thing that seems to me, based on the language of this bill, that it's prohibiting. Although I don't know how many people were actually going out there and they're requiring business licenses of every little lemonade stand that popped up. So as a practical matter, this may or may not, at least as to that part, make much of a change. But the second part of this bill relates to home-based businesses. And so the first one, again, it was any business from someone under 18. The second part here is home-based businesses. And what this says is that you can't charge a fee to a home-based business if the impact of this home-based business offsite is materially greater than the impact of just the residential use of that particular property. And so
we have a question.
We have a question here. So
about my friend Mike, he said he asked, how ironic is it that SB 81, this bill we're talking about, violates requirement in HB 232, which we just talked about, to have plainly stated standards of review. How does local government determine whether the impact of the business exceeds the impact of the residents? Great question.
That's very, very fair, very great question.
What do you think?
In terms of giving you a bright light answer, I can't do it. But I think it's going to be where in my view, what this is now going to require is at least some sort of particularized analysis by the jurisdiction to say, okay, how many trips are you having? You know, what kind of trips is this business going to generate? Are there any sorts of additional odors or sounds? I mean, there needs to be, I think, some sort of actual look at the particular business that's being licensed. I don't know that you can have sort of a one-size-fits-all approach.
I didn't see anything in the bill, too, about a threshold or a standard for exceeding the impact. Just exceeding the impact, you know.
I think materially is.
Not exceeding the impact to any, you know.
Just materially. So
yeah.
It can't just be a little bit. It has to be one of these great lawyer words, materially, I guess. You know, the HB 232 changes of not completely taking attorneys out of litigation on. So.
But it's good to keep in mind that this whole thing, came out of the idea of eliminating all business licensing.
Right.
And, you know, this is just eliminating the need for business licensing for things that don't cause a impact or a huge problem.
Right. And even on the one, you can license it, you just can't charge a fee for it. So, yeah, it's so I think that's SB 81.
Let's go back to that question by Rob. Back to the last bill. He said, what impact, no, I can't see it. There it is. What impact do you believe the new stricter requirements language will have on negotiated land use approvals, i.e. development agreements? My hope, Rob, is that it'll have none. It'll have none. As a matter of fact, if I had my choice, and I think you probably already know this, I think that stricter requirements language ought to be eliminated because it causes so many more problems than it solves. A negotiated a development agreement, a negotiated land use approval, means that the land use approval will be done largely by contract, which takes it out of LUGMA to a certain extent. And my hope is that negotiated land use approvals will continue and will be a great tool for people without having to worry about this stricter requirements language. The idea that says the stricter requirements cannot exceed what the state code says. To a certain extent, you can't do that contractually anyway, but to the extent that you can, I'm hopeful that you'll still be able to. That's my feeling about it. Though, Rob, who answered this question, is way smarter than me, so he may have, even better insight.
Okay.
Canal safety amendments. This is an interesting one. Years ago there was that accident up in Cache County, and those folks died, and ever since then, it seems like year after year there's more of an attempt to respond to that, to prevent that kind of thing from happening again, and make it easier for developers and canal owners and everything to understand their relationship.
Communicate.
Yeah, and communicate. So what did you see in this?
So this one, basically this makes a couple changes. One change, and maybe the biggest change, is that previously you had to give notice to a canal operator or owner when you received a land use application, a subdivision application, in order to have a vested right. This bill eliminates that requirement. It eliminates some other language, but then basically brings back very similar types of language, so that really what happens now, which is not too different from what happened before, which is you have to give notice. When you receive an application for a subdivision, you have to give notice to a canal owner or operator within 20 days of receiving the application. And then you have to wait for 20 days before you take action on that application for the subdivision in order to receive any sort of comments on, as you mentioned, the safety and that sort of thing from the canal operator owner. And what she clarified, it's still the same distance for the canal. It's 100 feet off the center line of the canal if the application is within that range.
So I guess the first thing for a local government to do is know where their canals are.
Right. Yep. And canals should be one, giving them information about that as well as the contact information. But there's a couple of provisions in the bill that state how you can go about determining whether there's a canal, where they are, and whether they're going to be within the 100-foot range. But yeah, that's something definitely to keep an eye out for, and keep in mind so that you can comply with that notice requirement here in this bill.
This idea that land use authority must wait for a response, I understand that's 20 days, is that right?
Yes, 20 days.
How do you think that affects the vesting rules, the rules about someone makes an application and you've got to kind of respond and in a reasonable time and approve them?
I don't know that 20 days is going to be problematic. I think that the normal vesting provisions still apply here, which is if you have an application that complies with the ordinances as they are written at the time that you submit it, you're vested.
Yeah.
You know, and so what this did do is I think it made it easier to get vested because it took out any sort of question about when you were vested. Because before you had to wait. You know, and that's gone from this now.
That's good.
And so, you know, I don't know that this is going to change too much of the vesting. In 20 days, at least to me, you know, off the cuff, doesn't seem to be too much of a burden. You're trying to balance public safety with, you know, the rights of the developer to move forward. Because they can continue to move forward. It's not a question of not being vested. It's just giving the canal operator owner a chance to come back with any comments on safety.
So you want to spend the rest of the time discussing whether or not Rob is smarter than me? Because I think that would be a valuable discussion.
That'd be a short discussion.
No, because you. Okay, let's move on.
No, fair enough. Okay. I hope I don't get fired now.
It's totally true.
So we have a couple of impact fee bills here, and the first one has more, I think, changes and solves a bigger problem than the second one. So as we look at this HB 279 impact fee amendments, impact
Where's
fees.
your copy of that one?
Impact fees, you know, certainly a fairly complicated area of law, and this, I understand, Brent, this bill addresses a particular area that was sometimes confusing and creates some problems.
You know, certain questions that you get sort of come and go. I'll get a lot of questions about a lot of things, and then that'll kind of go away. What this bill responds to, HB 279, responds to a question that I got like on my first day as ombudsman 10 years ago, and I've gotten consistently ever since. So you know that it's an issue. You know that it's longstanding and that no solution has been arrived to. And what this bill does is this bill answers the question of what do we do when we need to refund impact fee. I think it's fairly common knowledge that if you collect an impact fee, you have to spend or encumber it within 6 years.
Right.
If you don't, if 6 years passes and you haven't spent or encumbered that impact fee, you give it back. There's not a process, there's not a request that has to be made. Your responsibility under the law is to just refund it.
Automatic.
Yeah. And the question that I continually get asked is, to whom? Who do I give it to?
So the governments, just to clarify, the governments are coming to you saying, what do we do? We're trying to comply with the law.
Yeah.
How in the world do we comply?
Yeah, for the most part, it's governments wanting to do the right thing. Plenty of developers, though, have come to me and said, hey, I think I should get this back. You know, I think this should be coming to me, you know. And there's even been litigation on this that's gone to the appellate courts, and honestly, we're expecting an appellate decision on this anyway. But thankfully, the effort has been made to change this. This is in the code section here is 1136A 603. And what this, it sets up some definitions about who is the claimant, who is the original owner, and this provides a process, which they've done a great job. You notify the original owner of the right to the refund, okay, and you know, under most circumstances, that's the person who gets it, is the original owner, but not always. And it also helps because if no one claims, it gives you some, you know, a way to sort of put the money away. You know?
So this finally an answer to the question that sometimes you got, which is, what do we do when we have no idea and can't find who we give this to? There's no provision in the law to deal with this money. Is that?
Yeah, I'll just read this, and that's the reason I wanted to look at it, because I think reading it is the best way to express what happens here. If an impact fee is not spent or encumbered within the time specified, the local political subdivision shall refund the impact fee. Again, no request is necessary. Shall refund the impact fee. To, first, the original owner, if the original owner is the sole claimant. B, to the claimants as the claimants agree. So if the people who are saying that this impact fee, I paid this impact fee, it should be come back to me. If they can agree, you give it to them as they agree, right? If there are multiple claimants. Or interplead the impact fee refund to a court of competent jurisdiction for determination of the entitlement to a refund. So if only the original owner claims, they get it. If there's a dispute and they work it out, they get it. If there's a dispute, it's not the local government's responsibility to figure out who gets it at that point. The local government gets to get out of it. They get to interplead it, they get to give it to a court, and let those folks fight it out, and the local government is done. I like that. I think that's good stuff.
So we'll see if the questions keep coming.
Yeah, hopefully they won't. I think this does a good job clarifying things.
Great. So there's another impact fee here, Bill, as you mentioned, the HB 89 impact fee reporting requirements, and it does not certainly make as many changes or maybe solve any major questions you've been getting in your 10 years here. But can you just briefly tell us what this bill does?
Yeah, this bill, it's very simple, but it's important, especially for local governments who collect impact fees in their financial reporting. You already have an obligation to report impact fees to the state auditor. But what this does is this adds the obligation to account for the impact fees on hand as well. And I think, though I'm not a financial guy, and I never had to make this kind of report, but I think the word account is important. It's more than just reporting and saying we have this much on hand. You have to account for it,
more detail.
Yeah, where did it come from and how long have I had it and that kind of situation. So in a way, it relates to what came before. But I will definitely watch this and see how it ends up going before I make too many judgments on it. But I think it's a good thing. I think it's a very common perception among developers that impact fees are a big fat ripoff. Mm-hmm. They're not supposed to be, and if they're handled right, they're not. And it's my opinion that the vast majority of local governments who are charging impact fees are not interested in making impact fees a ripoff.
Right.
That may have been the case in the past where impact fees were looked at, hey, it's a great source of revenue. Right. We can collect revenue without raising taxes through impact fees and stuff like that. I think we know now that that's not the case. And I think we know now that when we collect money, we have to use it for what we collected it for, right? I think these kinds of bills that are in place, I think they give a lot of comfort to the idea that, we're not just taking this money and using it to go throw a party for our planning commission. We're taking this money, we're using it for what it's for, we're being more open about it, more transparent about it. If we have the money, we give it back. If we're not using it, if we are using it, we're reporting it and keeping it on. And that just gives comfort to the developer.
Right. It helps reduce the contention and the controversy over impact fees to begin with.
That's my hope.
Which is the hope that would end up happening.
Impact fees are never going to be popular. They're never going to be popular. It's taking money out of the pockets of the people who are helping us grow and helping us be stronger. And they're in a business. They're not altruistically developing in our cities, and no one expects them to not make a profit. You're taking their money away, and that's how they perceive it. But if they can see that they're getting value for that money, it makes it much easier to swallow. So they're never going to be popular, but if we can make it so they can trust the process, we're going to have a lot fewer problems.
And these bills sound to me, that's helping increase the trust.
I think so.
Helping increase the transparency, as you said. So
I think so.
Okay. So we made it to the final slide with just a couple minutes, so we'll be fairly brief here.
Local government plan review amendments. This one kind of has an interesting background, and it's like everything else, a big fat compromise. What can you tell us about that?
So there have been some issues from folks who have been submitting applications, building permit applications, on the time that in some instances it has taken to get plans reviewed. And so there was a perception by some in the development community that that's a problem that needed to be addressed. They felt like they were unfairly being delayed on their projects, which of course cost them money to move things forward. And so, this was a bill that was meant, and again, like many bills that we've discussed, started off much more broadly and then ended up becoming much more narrow in scope. But it's addressing a real problem that unless, the development community feels like it gets better, it's going to come back.
Yeah.
And so this specific bill does a few things. And maybe I'll start with the bottom, and that is there's a 1-year sunset.
Yeah, that was a critical part of the compromise.
Yes, a very, very, very critical part here. And of course, the whole point for that is to give everyone a chance to see how this works and to see if local jurisdictions can improve the time that it takes to get plans reviewed. Now, in some instances, and there's a lot of pushback from particularly smaller jurisdictions that didn't have anybody to review these plans. And so there was a sense that what you're asking here is we're not trying to delay anybody. We're not trying to, create more of a hassle for developers. There's just nobody that's available in that time frame to review these plans. And so if you punish us for this, it's unfair. And so this, again, was a compromise. And what this bill ended up doing is they put a specific time frame of 14 days for a single family or a duplex dwelling for residential use. The plans have to be reviewed within that 14 days. And they gave 21 business days for an international business, the IBC residential structure. Builders, not business, excuse me. For the residential structure. And, so this does not apply to plans relating to lots of different kinds of buildings. It's fairly narrow. And so specifically withheld or not included in this are the lodging establishments. So if you're building anything that's going to hold, where people are going to come for short-term stays, motels, bed and breakfast, etc., that does not apply here. And so the bottom line is if you do not get these plans for those particular structures reviewed within those time frames, and they have been stamped by a licensed architect or engineer. So that's an important detail here. If they have been stamped by a licensed architect or engineer, then the ability of the jurisdiction to review them is done.
Obviously, the problem here is that a lot of jurisdictions, especially more rural jurisdictions, don't have anybody to do this. And that's acknowledged, yeah. Yep. And and that's one of the reasons why the sunset was put on is to kind of see how this goes, because it's going to be tough. It's going to be a tough one to comply with.
Yeah, it will. So I think a takeaway here is to the extent that you have the ability, obviously, and I don't know that we've really heard too many. That there's any sort of widespread problem with jurisdictions not trying to do this already.
Yeah, exactly.
So, but just keep that in mind that that is an issue that has reached the legislature. They feel it's an issue, and to the extent you can do anything that will help mitigate that perception will help keep this bill in its type from resurfacing.
I vote that we skip this last bill and give people time for any questions. All in favor? Aye.
Okay.
The motion passes. Do you have any questions?
Yeah. Oops. Sorry, guys. I thought I was muted there. We did have a question on there or a comment on there. Classic example of using. Prime example of using a nuclear option to address a problem in just a few areas. This will force many building departments to not accept a building permit application until all aspects have been submitted to avoid the 14-day clock from starting to tick.
The important thing about that, and that is a really great point, Mike, the important thing about that is to remember that that's how legislation happens. Okay? Legislation happens based on anecdote, based on what stories they hear up there, which means that, they can hear one really outrageous story up there, propose a bill that affects all of us, even those folks who are doing this right. The nuclear option, like you're suggesting. It's good to keep that in mind, because the idea that this is just a one-off thing, it won't have any repercussions. That's not how it works. It comes back and bites you. And unfortunately, with this one, they were able to talk him into just trying it out because they were trying to drop the bomb.
Yeah,
on this for sure.
Sunset and much broader.
I have heard from several jurisdictions that say, I don't have anybody who is in this business anymore. No new students are going into this. All the people that were going into this have different jobs. How am I going to get people to do these plan reviews that fast? And I'm sympathetic, for sure.
So here's a follow-up question to that. Does the time frame include the zoning/site plan review or just the structural building review?
My understanding is just the structural building review, the actual plans that it would be, typically stamped by an architect and engineer.
Yeah, that's my understanding too. It really, the bill doesn't really even mention anything but the building.
Yeah, for a building.
So it's a great question, Scarlett. Thanks.
So we've got a question going back to the home-based business issue here. We have a trucking company that now has several large trucks because their business has grown. They were a home-based business. Now they're parking in the right-of-way. I would think that this exceeds the impact of the residents.
You know, it's tough. It's tough to go out on a limb on a brand new bill and say, oh yeah, that's what this bill addresses and that's what this represents. But you know, it seems like it does for sure. It seems like that's right where we're talking about.
With multiple semi-trucks, that's not a typical impact that a residence would have.
Yeah, I think that's clearly the intent of the bill, don't you, Jim? Is it's trying to say, you know what, if it's just a home and the fact that they're doing business out of there doesn't change the fact that it's residential, you're good.
If it's a couple people come a couple times a week, that happens at residences normally. And just because you have a business there does not then mean you get to license and charge fees.
You're cutting hair once a week, or you're having the kids over for a little dance class in your basement.
Well, there's not a lot of increased impacts, but you know, if you're running a semi-trucking business,
it's not the usual thing you see in a residence.
It doesn't seem typical without necessarily. It's not a typical impact.
Maybe an owner operator who's driving a semi truck and he parks at his home. That's probably consistent with a home-based business. But when we start adding multiple trucks, that may exceed that. Is that a good direction?
Keep in mind too that this is about business licensing, which really isn't a land use thing. It's related to land use, but it's not really a land use regulation. If you have a business license regulation, that doesn't give them or take away from them the ability to use the land in a certain way. All this says is that in this case you can't charge a business license. So if you have this trucking company, and sure, if it's like we're thinking it might, it exceeds the residential use there, well, great, you can charge them a business license, but that doesn't necessarily mean you can get rid of them.
Right. If it's that's exactly, Great point.
Okay. Great. All right. I don't see any more questions coming in, so we'll just throw it back to you for the final thoughts.
Okay, great. Well, we certainly appreciate everybody's time, and again, the trust for letting us come. I enjoy talking here with Brent. And if you have any questions on anything we've said, there's our contact information.
And if we can be of any help to you, if we can provide you with training, answer questions, I hope you know by now that that's what we're here for, and we enjoy that.
We do.
We enjoy visiting with you. I see from the list of attendees, a lot of you are friends and people that I've worked with and met before, and Jim. And it's delightful always to see you and work with you. And if there's anything we can do for your community, your county, your city, just let us know. We are lucky because we have great jobs. We feel like we get to help people, and we go home at night feeling good about that. So,
amen.
Great, thank you, gentlemen. I appreciate your time preparing this and sharing the information. We appreciate the partnership we have with the trust here, and we hope to continue to be able to provide this information a long time into the future. Thanks, folks, for attending. If you've got questions, please let us know. We'll be sending out a notice when this recording is available on our website, so you can go back and review or share that with other people. Thanks so much, and have a great day.
Thank you, everyone.
Thank you.